Ready, start. Further held. Next line A. Rule 3A states that no suit shall lie to set aside on the ground that the decree based on the compromise was unlawful. Obviously, the compromise referred to in Rule 3A can only be referable to the compromise envisaged in Rule 3. Under Rule 3, a compromise can be recorded only between the parties to the suit and not between persons who are not parties to the suit. Next para B. Thus, a decree passed by a court on the basis of a compromise can only be between the parties to the suit, and it cannot be between people who are not parties to the suit. In other words, the compromise recorded and decree passed thereon can only be between the parties to the suit, and it cannot be in respect of people unconnected with the suit. It is therefore follows that the decree passed in OS 525 bar 2014 can only be applicable to the parties to the suit, that is, the defendants, and cannot be made applicable to the plaintiff who was deleted from the array of parties. Next para. A compromise is in the nature of a binding contract between the parties. The parties who have entered into a compromise are expected to abide by the terms stated therein. It is for this reason that Rule 3A of Order 23 creates a bar for those persons who are parties to the compromise from filing a subsequent suit on the ground that the compromise obtained by them was unlawful. In other words, a binding contract entered into between two parties in a court of law cannot be annulled or impugned by the filing of a separate suit.